Hey everybody, I'm Lloyd Chatfield and this is the Business Law Bootcamp. Today we're going to talk about non-compete agreements. But first, our standard disclaimer. This video is for informational purposes only, does not create an attorney-client relationship, and does not constitute legal advice in any jurisdiction. Providing legal advice is what we do, but we don't do it through free videos on the internet. Non-compete agreements are very common, sometimes controversial, and this is one of those areas of business law where the law varies quite a bit from state to state. Whether you're an employer considering using non-competes, an employee who's been asked to sign one, or if you're faced with a potential enforcement, here's what you got to know. The two main scenarios where you're likely to see a non-compete are with employees and in connection with a business acquisition. I'm going to focus on employment non-competes, but we will talk about non-competes in the business acquisitions context at the end. A typical non-compete provides that an employee may not compete with the employer during the term of employment and for some period of time after employment ends. We don't see many disputes about employees competing during the term of employment. Where we run into difficult non-compete issues is when an employee subject to a non-compete leaves her employer and seeks to work for a competitor or seeks to go into competitive business on her own. Non-compete agreements are generally governed by state law, and states fall into three buckets when it comes to non-competes. California, as is often the case, is at one end of the spectrum. Basically, non-competes are unenforceable under California law. I actually got one of my clients out of a non-compete because the other side, a California company, chose to apply California law to their contract, unaware that that made their non-compete a non-starter. What's interesting is the contract was performed in Kentucky, and Kentucky falls in the other end of the spectrum. Kentucky will enforce non-competes unless they are unreasonable. In between general enforceability and general prohibition are states that place certain restrictions on non-competes, either by statute or their common law. Although state law is critical, in most jurisdictions there is a fairly common approach to non-compete enforcement. The basic idea in most states is that non-competes are enforceable if they are reasonable as to scope, duration, and geography. Unfortunately, this is an entirely subjective standard, generally applied based on all relevant facts and circumstances. As a result, it is often difficult to predict with much certainty whether a non-compete will be enforced. When a court is evaluating reasonableness of scope, duration, and geography, it looks at both the employer's legitimate interest and the burden imposed on the employee. This is a bit of a balancing act between the employer's interest and the employee's burden. So if an employer is in a highly competitive market and the employee has highly sensitive strategic information, that militates in favor of enforcement. But if an employer really can't articulate a business justification, enforcement is less likely. If your real justification is simply to force employees to stay with your company, a court might decline to enforce your non-compete. Likewise, if an employee has obvious alternative employment opportunities, so the hardship is minimal, that tends to support enforcement. So a widget salesman who has a proven track record selling cars, appliances, and life insurance might reasonably be prohibited from going to work for the only other widget manufacturer in town for a year. As I mentioned, non-competes can arise outside of the employment context, particularly in connection with the sale of a business. If I buy your banana stand for $1 million, I'm going to want to make sure you don't open another banana stand right next door. Courts are generally more willing to enforce non-competes in this context than in the employment context, because the party being restricted was basically paid to stand down. So for businesses looking to implement or enforce non-competes, here are a few pro tips. Number one, don't overreach. Know up front that to enforce your non-compete, it will have to be reasonable, so don't make them too broad. Number two, don't sheep dip. Not all employees are a legitimate competitive threat. Your custodial staff, clerical staff, and a lot of junior people probably should not be asked to sign non-competes. Number three, make sure you have an updated form that takes into account the applicable law. If you operate in multiple jurisdictions, you may have to tailor the non-compete language to comport with state law. Number four, get the non-compete agreement in place up front when the employee starts work or when they are promoted to a sensitive position. Some courts look askance at non-competes adopted after the employee starts work. Number five, enforce non-competes judiciously. I've helped a lot of employers evaluate enforcement of non-competes. In my experience, because there is almost always a reasonableness standard, I advocate being reasonable up front. If an employee is so bad that you fired them, maybe you should hope they go work for your competition. I've been in front of judges trying to enforce non-competes and trying to get my clients out of them. When I can demonstrate to the court that my client only enforces non-competes to the extent necessary to protect the business, I've gone a long way toward ensuring enforcement. So that's it for non-competes. Thanks for watching Business Law Bootcamp. We'll see you next time.